talk about the impeachment and more, we have on the show once again UP Law Assistant Professor Paolo Tamase. UP Diliman has released, of course, a statement for this impeachment trial to proceed forthwith and talking about it, about this 19-day expedited impeachment trial. I'd just like to ask you again, because we didn't get you quite clear a while ago, is it possible to have this trial done in 19 days?
Again, so I hope this is much better.
Yes.
I think the 19-day trial might not be realistic. We can compare it to the practice of the Philippine Senate in the Corona and Estrada trials, where the trial was much longer than just 2 days per side. And the reason why it's like that is because there's also a lot of opportunity for senators to ask questions from the witnesses. There's also a truth-telling aspect to that exercise. And I don't think it will serve the purpose of accountability to rush the trial. The schedule seems to be premised on this idea that the trial must finish by June 30. And I think the statements of my colleagues in UP Law, as well as the statements of some of the other universities and law schools that followed us, make it clear that there should be no concern about the trial not being able to cross over from the 19th to the 20th Congress.
There is also a proposal from the office of Senator Tolentino to trim the impeachment articles from 7 down to 2 to make that expedited trial possible. Ang sabi niya, yung dalawa, doable na yun. Piliin na nila yung sa tingin nila ay meron silang sapat na ebidensya. Sa ganoong paraan ay talagang mapapabilis ito. Is that even legal? I mean, trimming it down?
It did happen in the Corona trial. So there were similarly numerous articles of impeachment in the Corona trial in 2012. Ultimately, if I'm not mistaken, the House ended up presenting just 2 of the articles of impeachment and sought and secured a conviction on that basis. But if I'm not mistaken, in the Corona trial, it was the House that decided to do that. So ultimately, it's the House panel or the House managers who will make that call. Of course, Senator Tolentino and the other senators are free to make that suggestion, but I would, desist from micromanaging. If I were a senator, I would desist from micromanaging the way that the parties present their evidence, since they're supposed to be a neutral arbiter in the case, and therefore they can't get too involved with which evidence which party is presenting.
Okay. But if you take a look at the 7 articles, which do you think are the most potent? I mean, the first one is the conspiracy to assassinate the president, the first lady, and the speaker. The second one is the malversation of 612.5 million in confidential funds. The third article is bribery and corruption in the DepEd. The fourth is unexplained wealth and failure to disclose assets. Article 5 is involvement in extrajudicial killings. Article 6, destabilization, insurrection, and public disorder. And the 7th one is the totality of the respondent's conduct as vice president. Which 2 are the most potent?
Well, Gretchen, I hope you understand. I really can't comment yet on which ground would be most potent. Myself, and the reason why the UP Law faculty wrote the letters to really ask the Senate to allow the public to see the evidence. But if we go by history, we do have an experience with the SAL-N issue, the failure to disclose accurate statements of assets, liabilities, and net worth. Indicates a lack of ability. If we go by the Corona impeachment, the lack of an ability to hold the public trust and keep that public trust. So that might be something that they'd want to consider. On the other hand, some of these grounds have been subject of extensive House hearings, and therefore there would be, as expected, a large amount of evidence that the House might want to present. So these would be some of the factors probably that would come into the consideration of the House managers.
I do remember in the impeachment of Joseph Estrada, there was, the opening of the second envelope was put to a vote. if ever this trial gets to that point where the bank accounts of the vice president would be opened, would that also be put to a vote?
We have to put the Estrada bank accounts in a very specific context. Um, as you probably are alluding to, there is a Bank Secrecy Act in the Philippines which prohibits the exposure or the disclosure of bank accounts by banks to the public or to third persons. There's an exception in local currency deposits for impeachment. So impeachment is one of those proceedings that are excluded from the Bank Secrecy Act for local deposits at least. In the Estrada impeachment, the reason why it was put to a vote was there was an objection on the materiality and relevance of the evidence in relation to the article of impeachment being proven at the time. The position of the defense lawyers was that the second envelope and its supposed contents would not be relevant to the ground for impeachment, which is a legal objection, a fair legal objection. What might be interesting this time is that, or to emphasize, as we do in the UP law statement, is that the people don't like it when we focus on these legal technicalities as a way to stop the truth from coming out. So the reason why EDSA 2 was triggered was because the people didn't see that as a legal objection. They saw it as suppression. And it was a warning that we thought would be good for the Senate in light of the fact that the Senate is also accountable for the trial and the way that it conducts it.
With the relevance of the bank accounts to an article about 3 articles of impeachment that I read a while ago, is it possible to open those accounts without going into a vote?
I think so. The way that this would work, and I wish I could give you a clear answer, but the way that this would work is that procedural objections, if we follow the Corona trial rules, procedural objections are generally addressed to the presiding officer or the Senate president in this case. If there is an objection from any of the senators about that ruling of the presiding officer, then it is put to a vote of the whole Senate. So it might be possible for it to still go through a procedural vote, even if there's no serious objection to it. Now, I'm not saying that there's no objection. I haven't seen the case myself, other than the complaint, and there might be reasons for the defense to ask for the non-disclosure of those accounts. But if any senator asks for a procedural vote under the existing Senate rules, then they would get that. They would have that right.
And if it's possible in the trial itself, could that also be possible to pressure the presiding officer to act now? I mean, to act earlier. It is June 9, 2 days ahead, 2 days ahead of the calendar that Senate President Jesus Escudero has put out. I know it's not a lot, but is that possible to put that to a vote, to pressure him to have this earlier?
No, I think this goes into the way that the Senate really manages the chamber. And if I'm not mistaken, and this is not currently my field of expertise, the decision to table or to schedule item for agenda is currently with the Senate President. And therefore, they really do take the lead from him. Now, there's a theoretical possibility that if they want it scheduled earlier, they can pressure the Senate President. And the pressure comes from the fact that the senators ultimately get to decide whether or not a Senate President still sits as Senate President. But I don't think they're on the way to that. My sense is that just because it's important to get the trial started before they go on final adjournment, then any sign that the trial would continue, even if it's still on June 11, might be enough just to dissuade any efforts to essentially short-circuit the process.
As we talked about earlier, many universities have already released their statements. There are those going out to the streets. At this point, given the, I guess, the behavior of the Senate, is there any other recourse for the people to take to demand some sort of accountability from the Senate and how it has been acting, how it has not followed the Constitution to proceed forthwith?
So I'm going to go and mention one of the things that's been floated, which is filing a case with the Supreme Court. And there have been, indications from some parties that if the Senate does refuse to act, that they would be prepared to take it all the way to the Supreme Court and ask the Supreme Court to mandate the Senate or to to issue a writ that would order the Senate to start the trial. But my based on my own study and scholarship, there's a reason not to go that route to trigger happily. Um, Bringing in the Supreme Court on this matter is not really consistent with a mature democracy. The Senate is the one that is textually vested by the Constitution with the power of trying an impeachment. And therefore, the first pass at these questions should be with the Senate. Now, if they refuse, the real design of the system is ultimately to hold the senators accountable in elections. And that means that people should be watching these events closely because they might be an indication of which senators have a commitment to constitutional accountability and those which don't. But I'm not discounting entirely the possibility that the Supreme Court can step in. It's just that based on the information that we have now, I'm not yet sure if we're there yet. But that can change very quickly in the next few days.
In simple terms, pwede bang sabihin ng Supreme Court, for example, ikaw, Senate President Jesus Escudero, dinelay mo yung proseso and you should be held accountable. Walang ganon? Walang ganong possibility to hold him accountable for his actions?
I think may kapangyarihan sila, no? Kung gusto talaga nila ipasimulan yung trial, yung paglilitis, pwede nila gawin yun, right? That's within their expanded jurisdiction. But whether to hold Senator Escudero accountable is a different question. In our constitutional system, senators are only disciplined by their own chamber. In the same way that members of the House are disciplined only by their own chamber. So they are not accountable to the Supreme Court or to any court. They're not accountable to the president. If you want a good example, this is what the House did with Representative Teves when they expelled him from the House. That would be the way of the chamber holding their own member accountable. Pero hindi pwede pag-utos ng Korte Suprema yun. Our system doesn't allow it.
Okay, what is the jurisdiction of the Supreme Court in terms of the matters that it can discuss in its court? Because there have been several petitions already filed. One of which is, for example, whether pwedeng tumawid dito from the 19th to the 20th Congress. What is within the bounds of their power?
Look, the Supreme Court has asserted what we call expanded jurisdiction. So according to the Supreme Court in a 2004 case, which also involved impeachment, that even though impeachment is usually a political question, it's a question that is left to the political branches and one that the court doesn't intervene in. There are standards in the Constitution that place limits on the power of the House and the Senate to conduct impeachment. Or an impeachment trial in the case of the Senate. So when those standards are breached, the Supreme Court can step in. That's something that we've asserted as early as 2004. But just because the Supreme Court has the power to step in doesn't mean that it always steps in or that it should step in. There is what we call requisites for judicial review. There are many other prudential devices that they use to avoid deciding highly politicized questions. We don't know yet whether the court will use those devices to avoid deciding a petition that was filed before them. Although it is worth noting that the petitions that were filed in February asked for immediate relief and the Supreme Court has not granted any of them yet. So it looks like the court is also waiting and seeing.
Hindi ba maaari ring magkaroon ng constitutional crisis kung sakasakaling hindi sumunod itong Senate? And is that something that they're also being very careful about? Because ultimately, I mean, don't you see it heading that way? Kasi kung tumawid ito, magkaroon tayo ng mag-convene as an impeachment court, hindi rin talaga sapat yung oras. Tatawid din talaga dito sa 20th Congress. If hindi siya tumawid, there could also be cases filed. What are your thoughts on that, and how do you see this playing out?
Yeah, no, it's a difficult question. And pag impeachment kasi, you have to recognize that we don't hold trials frequently. We hold them once every decade plus a few years. So a lot of the rules that could have been clarified are not really clarified until they are there, right, before the Senate.
Yes.
So the possibility of a constitutional crisis hangs over any form of impeachment. But I mean that it's only a constitutional crisis if the branches don't act according to their duties and their powers. So I wouldn't want to put, or ayoko pangunahan, yung constitutional crisis na yun by assuming that the Senate will not do its job or that the Supreme Court will overstep its bounds. I do think that the Senate will ultimately continue with the trial. I do think that the Supreme Court, if it intervenes, will intervene in a prudential way. But I think if you look at the system that we have as a whole, the only reason why it's worked is that there's a conscious recognition by the branches of the extent and the limits of their powers. And I'm hoping that at least this impeachment, even though it presents very difficult questions, will call to the better selves of our leaders and that they will act in accordance with accountability.
And that, of course, is under the presumption that people understand what impeachment is all about. I mean, most of the Philippine population, at least. But this week, we will see how our Senate leaders confront this issue as the Senate adjourns. Correct me if I'm wrong. Sine die, tama ba? Or sine die?
Sine die.
Sine die.
Yeah.
I've been waiting for the correct pronunciation.
Gretchen, when you think about it, the only reason why we averted crises in the past impeachments was the people remained involved. And that's a call for citizens to stay involved with impeachment, to go past the legalese and all of these formalities and really look at the core question of, did Vice President Duterte violate her constitutional duties? Is the Senate fulfilling its duty to try her fairly? The people's involvement here puts a pressure on the branches to ensure that they are acting accordingly.
Well, we will get to see what happens in the coming days. In the meantime, thank you so much for explaining all of that with us. We have Professor Paolo Tamase of UP Law.
Thank you.